I'm not really a constitutional law expert, so if I'm wrong in this, there are people in this room who might correct me, but my understanding is that in Canada, not only do you have this sort of adverse costs rule that may be a disincentive to this kind of litigation, but you also lack, even under rational basis, any theory of constitutional interpretation that would permit the kind of litigation on economic or property rights that you're talking about. There may be ways around that, but I think that basic fact remains that while other kinds of litigation are possible when it comes to personal rights of various kinds, if you're talking about a purely economic or property right, I don't know that there's a door that's even slightly ajar in the Canadian constitutional context.
I think that may be true. I'm not in any sense an expert on the Canadian Constitution, although I know we were having lunch the other day with someone who is involved with the Charter, actually getting various parts of the Charter, and was talking to various premiers about supporting a property rights component of the Charter. And everybody's like, oh, we don't want property rights. We have property rights in the Charter. All of a sudden, we're not going to be able to condemn people's land and take it away from them. So the Canadian, you know, the Canada's written constitution was created in a context in which is just drastically different than the United States, both culturally and, you know, Canada's constitution was put together through, you know, kind of political consultation and things like that. You didn't have a civil war against a foreign power like the U.S. did.
Well, as a matter of fact, again, I'll betray a bit of my ignorance here, but my understanding is that there was explicit contemplation of this issue in the drafting and the framing of the Charter, and of course Lochner was invoked as a kind of boogeyman that we don't want to touch this, and therefore that, I think that even influenced some of the early cases above the Canadian Supreme Court saying no, there's no protection for economic or property rights in the Charter.
Yeah, I mean, Lochner is, this case he's talking about, Lochner, I don't know if people know about this case, but anyway, it's one of the most famous cases in American constitutional law. It is probably the most misunderstood and therefore most loathed decision in American constitutional law. And it was a decision in which the Supreme Court invalidated a minimum number of working hours law, or a maximum number of working hours law in New York for bakers. It was a decision from 1905, and it was basically, you know, New York said you couldn't work more than 60 hours a week as a baker because it's unhealthful to be around flour and other, you know, bakeries are hot and that kind of thing. So we want to protect bakers by imposing this law, and the Supreme Court said no, that violates the contract rights of bakers who want to, you know, if they want to work more than 60 hours a week, they have the constitutional right to do so. And Lochner, among the cases like Caroline Products that I mentioned from the 1930s, which introduced the rational basis test, that line of cases that came out of the New Deal expressly overruled Lochner. And the decisions from Lochner kind of leading up to the New Deal were the ones that were protecting some basic economic rights against the government. Now, the thing about Lochner is that there has been a lot of, you know, so Lochner supposedly stands for the proposition that the Supreme Court was using constitutional rights to prevent progressive social legislation that would protect workers. And so Lochner is this terrible decision because the government should be able to do things like protect workers, which is actually true. I mean, you know, even at IJ, we don't have any objection to laws that are designed to protect actual public health and safety. But there's been a lot of history on Lochner, and actually what was going on is that you had German bakers in New York, and German bakers like to work X number of hours. And then what started happening right around the turn of the century? A bunch of Jews started showing up. And the Jews were willing to work longer than the Germans. So what do you do if you're a German who's being outcompeted by a Jew? Well, that's actually a bad question because we know what happened in the 1930s and 40s. But what you do in New York City is you lobby the state of New York to pass a law that imposes a maximum number of working hours. And so this was a law that was not principally designed to protect public health and safety. That's how it was justified. But that wasn't what its purpose was. Its purpose was to ensure that a particular ethnic group was able to prevent immigrants, like new entrants to the market, from exploiting their comparative advantage, which was a willingness to work harder. So Lochner is gradually being rehabilitated, but certainly at the time when the Canadian Charter, and even now in constitutional law in America, Lochner is sort of like a bad word. So I can see that. Sorry. is this one here? This one will work. I mean, if I can use this one. It doesn't seem... Sorry, Pat. There you go.
Okay. In Canada, among some of the Supreme Court cases, I think the most popular one I've heard of, just among people who aren't familiar with legal circles, is the FEC versus the Hillary Clinton.
Oh, Citizens United.
Yeah, Citizens United.
Yeah.
Thank you. That's the one I've heard most in a lot of my poli-sci classes, especially. Could you talk a little bit about that case in more detail?
Sure. So Citizens United was a case about a movie that was made about Hillary Clinton that was intended to prevent Hillary Clinton from successfully getting the nomination and then being elected president in 2008. This was the purpose. It was pure political speech. We don't like Hillary Clinton, so we're going to make a movie, and we're actually going to buy time on different, almost like an infomercial, on different cable channels to play this thing called Hillary the Movie. And the organization, one of the organizations that was involved was called Citizens United. And the Federal Election Commission in the United States said, you cannot distribute this, Citizens United cannot distribute this movie because Citizens United is a corporation. And there are restrictions on the amount of money that corporations can spend in intense and complicated, like IRS level restrictions on what corporations can do. And so that means that unions and nonprofits like Citizens United that are trying to make political points and stuff like that didn't have free speech rights. And so this case eventually went up to the Supreme Court, and the Supreme Court said, look, this is core political speech. These are people who don't want Hillary Clinton to be elected. Now, it turns out that they have organized themselves in the form of a corporation, and people often organize themselves in ways to make their speech more effective. Labor unions are a good example, nonprofits like the Sierra Club, things like that. And the Supreme Court said, in a nutshell, that we're going to consider corporations and unions and other legal entities to have free speech, political free speech rights, because they are essentially just doing the things that people do. Or in other words, they're just articulating political ideas, and political ideas have core constitutional protection in the states. Now, everybody hates Citizens, well, not everybody, but I mean, there's like this huge backlash against Citizens United because people think, oh, corporations have free speech rights. Well, corporations aren't people, only people have free speech rights. We hate this. This is the worst decision ever. Like, we're going to have Walmart is going to be able to start making political statements. Nike will start to be able to make political statements, blah, blah, blah. So everybody hates it. But step back and consider something very important. Of the people who hate Citizens United, or if you're inclined to rebel against the notion that Citizens United is a good decision, why? The reason why is because you think that someone out there someday is going to say something you don't like. And they're going to say something that's going to be persuasive. And so the instinct behind the disapproval of Citizens United is, I want to censor ideas that I don't like. That's it. So whether it's a corporation speaking or it's an individual speaking, corporations can only speak through individuals. And so whenever a message is being conveyed, it is being conveyed by someone. And the fact that, at least under the US Constitution, the fact that you don't like what they're saying is irrelevant. They're allowed to say it. And so we have been, we filed a brief in support of Citizens United. We actually do a lot of campaign finance stuff at IJ, although we don't do Citizens United level stuff. We do stuff that has to do with grassroots political organizers who are being subject to campaign finance laws by their political opponents. But anyway, bottom line about Citizens United, I think that is also a misunderstood decision. And I think that the impulse behind disliking Citizens United is the impulse to want to retain the political power to suppress political opinions that you don't like. Because it's not just Walmart that's going to be talking. Target is often supports liberal causes. The Sierra Club, unions should be able to talk. I presume that people who don't like Citizens United would think it would be, they don't want to suppress unions from being able to talk about things that are good for workers. So that's my take on Citizens United. I'm sorry, go ahead, ma'am.
Mine might be simple for the room, but I'd like to understand a bit more about precedent. Can a previous precedent be replaced with its opposite?
Yes.
Or do you have to create something that's like it but creative?
Right. So when a law gets passed, there's a doctrine called Starry Decisis. It's a Latin word, and it basically means it's just a decided decision. And so after a court makes a decision, they're really reluctant to overturn the decision because that creates instability and it delegitimates the court. So you can overturn decisions, but courts are, especially the Supreme Court, is reluctant. I could give you two famous examples, though. There was a decision in the late 1800s called Plessy V Ferguson. That's the separate, this is a case about separate but equal, saying that, well, just because there's one part of the train is for blacks and the other part of the train is for whites, sure, they're separate, but we consider them equal. That's not a violation of the Equal Protection Clause of the U.S. Constitution. It's clearly ridiculous. It's just like naked mistreatment of people on the basis of their race. So then in the 1950s, you have a famous case called Brown v. Board of Education, which reversed, overruled Plessy v. Ferguson. It took 60 years, basically, for them to do it. But courts will do it. Another famous example is in 1983, the Supreme Court had a case called Bowers v. Hardwick that was about criminalizing private homosexual conduct. Supreme Court said that it was constitutional to criminalize that, upheld a Georgia law, and then in 2003, in a case called Lawrence v. Texas, the Supreme Court essentially it reversed itself on Bowers v. Hardwick and said that the government cannot criminalize private adult consensual homosexual behavior. So there are instances in which it's done, but it doesn't happen very often.
So we'll take one more question.
Yeah, this is a bit of a hefty question, but surrounding the Civil War and the secession of the Confederate States, what's the constitutional legal basis for that? Was it constitutionally justified for them to secede, or was it an illegal action, so to speak?
Yeah, it's sort of an interesting question. So the basic, the whole point of the Civil War was the South is saying, look, we're out of this, right? The whole point of the United States was that these were sovereign states coming together to create a more perfect union to protect the rights of their citizens. And so implicit in that in the notion of self-government is that which you form can also be broken. And so the legal theory on the side of the Confederacy was, we are opting out of the United States, we're seceding. And Lincoln said no. That's it. I mean, there's no real basis for it. There's no legal basis for it. It actually seems to me that the southern states constituted an abhorrent tyranny. Slavery is the worst possible economic institution you can imagine. They suppressed rights of self-defense, they confiscated weapons, they suppressed speech. Like, southern governments were tyrannical governments by modern standards. Like, you think to yourself, like, this is like Iraq, circa 1980s, in terms of the freedoms that people would have had, at least abolitionists who supported getting rid of slavery. So these are terrible governments. So nevertheless, like, legally, it actually seems to me that if a group of people don't want to be part of a country anymore, they should be able to leave. I don't know how to make it equitable, but the precedent now is that if you try to leave, we will conquer you and force you back into the Union. So I don't think there's no such thing as a kind of a constitutional theory of secession in the United States.
Well, on that interesting note, since we have secession issues here in Canada, which we won't get into, I would just like to thank you very much, Jeff, for a really interesting short course in American constitutional litigation. And it's been particularly interesting to hear how strategic your organization has to be with respect to getting some of these cases through the courts. So we have our own issues here, right to die, physician-assisted suicide is an example, but it's been very, very interesting. So I, on behalf of everyone here, like to thank you very much.
Thank you. My pleasure.
Interesting talk.